All right. Welcome to a reading of our nice little court case that happened not too long ago. Let me adjust this here so this way it's more centered. Anyway, we're going to take a closer look at the court decision that reversed the whole drone registration thing. Of course, now I want to start coughing even though I drank a bunch of water earlier. But let's go ahead and get into the nitty-gritty with this one. United States Court of Appeals for the District of Columbia Circuit. This was argued on March 14th. I ended up uploading the oral arguments for this one not long ago. A few months back. Well, it was about a month back when I first learned about that I went to oral arguments in the appeals. And it was decided earlier this month on the 19th. Docket number 15-1495. John Taylor is the petitioner. Good job, man. And the person that was arguing it on the defense for the FAA was Michael P. Huerta, I think it was, how it's pronounced. Let's see here. John A. Taylor, pro se, argued the case and filed briefs for petitioner. Ben Sperry was on the brief of amicus curiae, tech freedom, and freedom for support of petitioner. Abby C. Wright, attorney. We can sort of skip all this fun stuff here. Just nitty gritty stuff. Alright, let's go ahead and get to the thing. Opinion of the court filed by Circuit Judge. I'm not sure how to pronounce that. I think that's Kavanaugh or Kavanu. Yeah. Anyway, Congress has charged the Federal Aviation Administration with maintaining the safety of national air traffic. As small unmanned aircraft, sometimes known as drones, has become more popular and the number of unmanned aircraft related safety incidents has increased. In 2015, in an effort to address that trend, the FAA promulgated a rule known as Registration Rule. That rule required owners of small unmanned aircraft operated for recreational purposes to register with the FAA. Unmanned aircraft operated for recreational purposes throughout this opinion separately. The FAA pushed a notice known as Advisory Circular 91-57A, announcing that model aircraft would be subject to certain flight restrictions of Washington, D.C. area. Petitioner John Taylor, in the model aircraft hobbyist, who is now required to register with the FAA, has operated model aircraft from his home in Washington, D.C. area, and he wants to continue to do so without registering or complying with the new flight restrictions. Taylor filed a petition in this court to challenge the FAA's registration rule and the advisory circular. To begin, Taylor does not think the FAA had the statutory authority to issue the registration and require him to register. Taylor is right. In 2012, Congress passed and President Obama signed the FAA Modernization and Reform Act, Section 336A. That act states that FAA may not promulgate any rule or regulation regarding a model aircraft. Publication L number 112-95, Statute 336A, Statute 1177, 2012, codified at 49 USC, Statute 40101 note. FAA's 2015 registration rule, which applies to model aircraft, directly violates that clear statutory prohibition. We therefore grant Tyler's petition to vacate registration rule to the extent it applies of model aircraft. And this right here, the 336A, was the huge part and why it was pretty much thrown out. A lot of people were going, "What are you doing?" The Congress said you're not supposed to add anything, well, any major rule change kind of thing. No new regulations for the hobbyists for the most part. And the FAA was talking out their ass, arguing that this, like, oh, we're gonna be able to do this. And if you listen to the oral argument, it was quite interesting how badly the FAA's representative there got chewed up by the judges. Tyler challenges Advisory Circular 91-57A on the ground of the circular, likewise, violation section 336A. That circular prohibits the operation of model aircraft in various restricted areas, including the flight restricted zone around Washington, D.C. But Tyler petition challenging the advisory circular is ultimately, by statute, a petitioner must challenge the FAA order within 60 days of the order's issuance unless there are reasonable grounds for delay. 94 USC 461110A. Tyler acknowledges that he filed his petition challenging the advisory circular outside the 60-day window. He did not have reasonable grounds for the late filing. His petition for review of the advisory circular 91-57A is therefore denied. Congress has directed FAA to promote safe flight of civil aircraft and set standard governing the operation of aircraft in the United States. 49 USC 44701A. Congress he has also required aircraft to be registered before operation. CID 44101 44103. To register, aircraft owners must complete registration process that is quite extensive, as one would imagine, for airplanes. But the FAA has not previously interpreted the general registration statute to apply to model aircraft. Instead, the FAA has issued an optional set of operational guidelines for model aircraft. The FAA's Advisory Circular 9157, -57, titled Model Aircraft Operating Standards and published in 1981, provided suggestions for safe operations of model aircraft. Under the advisory circular, compliance with the circular by operators of model aircraft was voluntary. Ooh, they even state it right here that compliance with that circular is voluntary. As unmanned aircraft technology has advanced, small unmanned aircraft have become increasingly popular. In response, the FAA has taken a more active regulatory role. In 2007, the FAA promulgated a notice announcing a new regulatory approach to unmanned aircraft. See Unmanned Aircraft Operations and National Airspace Systems 72 Fed Regulation 6689, February 13, 2007. In that notice, the FAA distinguished between commercial and recreational unmanned aircraft. Under the new regulatory approach, commercial unmanned aircraft are subject to mandatory FAA regulations. Those regulations require operators to report the aircraft's intended use, time or number of flights, and area of operation, among other things. By contrast, this notice did not alter the long-standing voluntary regulatory approach for model aircraft. In 2012, Congress weighed in on the debate over regulation of unmanned aircraft. Congress passed and President Obama signed the FAA Modernization Reform Act of 2012. Drink some water here. Let's see. Publication L 112-95 statute. 126 statute 11 codified at 49 USC. Statute 40101 note. The Act codified the FAA's longstanding hands-off approach to the regulation of model aircraft, specifically Section 336 of the Act, called the Special Rule for Model Aircraft, provides the FAA may not promulgate any rule or regulation regarding model aircraft. The Act defines model aircraft as an unmanned aircraft that is capable of sustained flight in the atmosphere flown within visual sight of the person operating the aircraft, and flown for hobby or recreational purposes. Let's see here. Notwithstanding that the clear statutory restriction on the FAA regulation of model aircraft in December 2015, let's see here. The FAA issued a final rule requiring owners of all small aircraft, including model aircraft, to register with the FAA. See registration with the FAA. See registration making requirements of for small unmanned aircraft. The registration rule requires model aircraft owners to provide their names, physical, mailing, email addresses, and any other information the FAA chooses to require. At 595-96, registration rule also creates an online platform for registration, establishing a $5 per individual registration fee. Sets compliance deadlines and requires all small unmanned aircraft to display a unique identifier number issued by the FAA. Model aircraft owners who do not register face civil or criminal mandatory penalties and up to 3 years imprisonment. And it seems my little data thing on the side here is not registering people's chats in the thing. I just turned it on my cell phone here to see if anybody was tuning in, and there are people that are tuned in. So I'll fix that. We'll see about fixing that here in a minute. Also, in 2015, the FAA withdrew the Advisory Circular 9157 and replaced it with Advisory Circular 9157A. See JA 3-5, among other things. The revised circular provided that model aircraft could not fly within restricted zones covering Washington, D.C. and surrounding areas without specific authorization. Oh, that is very interesting. So, what was it? Underneath the original circulatory, there wasn't anything that's banned UAS flights or drone flights in Washington, D.C. And then when they changed it up, they put in D.C. is no longer a fly zone. So this is actually quite the interesting thing. This case might actually change some stuff when we get to the decisions. Petitioner Tyler is a model aircraft hobbyist living in Washington, D.C. area. Tyler argues that Section 336 of the FAA Modernization and Reform Act bars both the FAA's registration rule and Advisory Circular 91-57A. So, the question is, we know the registration got thrown out. What about the advisory? We're going to have to see about that. And let me take a look here and double check what's going on. Yeah, let me check my settings here on my little thing. Counts, appearance. Why is it not showing up with your guys' chats thing? Because the overlay that I have set up is supposed to grab the chat data from the YouTube chat so I can see it without having to pull up another window or anything like that while I'm trying to do all this. That's connected. Export. That is very troubling. Let's see here. I think I might know what's going on here. Give me a second here. Let me try to reconnect this here. Then I'll give this a test quick. Oops, okay. Okay, broadcaster thing should show up on that. Okay, that said test. Now let me double check my thing, because this was working just fine. last time I used this setup, and I'm wondering what's going on now. Is it? Yeah, it's not even showing up as a. All right. Well, I'll have to, unfortunately, figure something else out here. I'll set up a secondary window where this is just running in the background kind of thing, so this way it can be seen. Now where's window capture? That one. Not the restream. No, not that one. Ah, that one. That one works, yes. And just do that, and then we'll move this over here. There we go, that fixes that. So this way everybody can see their chats. Yeah, it's we're getting into the 60s over here in Alaska. Yeah, I know it didn't work because I wanted to. Yeah, that seems to be the ongoing situation for me all the time. Is that actually, no, okay, no, that's plenty of room there. All right, let's go ahead and get back to reading. Sorry guys, I won't be able to really see what you guys are saying. I'll actually set my phone up to look at the chat here. And also, there we go. Okay. Now I should be able to have that going, and I'll see about fixing that later for another live stream here. Oh, perfect. That works out pretty good. All right. Oh, double check to make sure I'm not draining data from the cell network. There we go. All right. Let's move on to section 2. We first considered Tyler's challenge to the registration rule. Section 336 of FAA Modernization Reform Act of 2012 provides that FAA may not promulgate any rule or regulation regarding model aircraft. Publication L, number 112-95336A, 126 Statute 117, 77, 2012 codified at 49 USC 40101. Note, FAA's 2015 registration rule is undoubtedly a rule. By requiring prospective registration of all model aircraft, the registration rule announces an FAA statement of general and practical particular applicability. Dang, I can't speak. Applicability and future effects designed to implement, interpret, prescribe law or policy. 5 USC 5514 defined rule for the purpose of Administrative Procedure Act. In addition, FAA registration rule is a rule regarding model aircraft. FAA Modernization Reform Act 336A registration rule sets forth the requirements for small unmanned aircraft, including small unmanned aircraft operated as model aircraft, registration and marking requirements for small unmanned aircraft, 80 Fed registration, 78,594 and 78,594, December 16th, 2015. Oh, okay. Wait. Those are the same numbers. Why did they repeat them? Lest there is any doubt about whether the registration rule is a rule regarding a model aircraft for the purpose of Section 336. The registration rule states that the definition of model aircraft is identical to the definition provided in Section 336. What was it? Dang it, I lost myself here for a sec. Is identical to Section 336C of Public Law 112-95, FAA Modernization Reform Act. In short, the 2012 FAA Modernization Act Modernization and Reform Act provides that the FAA may not promulgate any rule or regulation regarding a model aircraft. Yet FAA's 2015 registration rule is a rule or a regulation regarding a model aircraft. Statutory interpretation does not get much simpler. Oh, I love that. Statutory interpretation does not get much simpler. So literally, the obvious right there. Hey, Rennie, the obviously stated saying these rules say you can't do it, yet you did it. The registration rule is unlawful as applied to model aircraft. This is just perfect because I loved how the FAA got reamed by the judges during the oral argument, specifically around this issue. And the FAA, when anybody countered, pointed out that this act, the 336A, the 336 section, applied to this issue, that they could not do it, yet they still did it, and they're talking out their asses. Right here states that, yeah, it's obvious you broke the fucking law. And it just makes you wonder what the hell is going through their heads. Oh, we're just going to go ahead and pass it. Yeah, I guess I can skip the numbers. Okay, let's go ahead and continue on. The FAA's argument to the contrary are unpersuasive. First, the FAA contends that the registration rule is authorization by pre-existing statutory provisions that are unaffected by the FAA Modernization and Reform Act. Specifically, the FAA notes that under long-standing statute, aircraft are statutorily required to register before operation. See 49 USC. But FAA has never previously interpreted that registration requirement to apply to model aircraft, which is very true. For the longest time, model RC aircraft, those that are operating like little helicopters or the prop planes that flew around, or even the little turbine jets for the fun little hobby get-togethers, will fly circles and stuff, never had to register beforehand. And I flew RC aircraft long before all this stuff happened. And I didn't have to do any registration or anything like that. It was, I would go to a park and I'd fly, or go to a large open parking lot and I would fly. The FAA responds that nothing in 2012 FAA Modernization and Reform Act prevents the FAA from changing course and applying the registration requirements to model aircraft now. The FAA claims the registration rule is therefore not a new requirement at all, but merely a decision to cease its exercise of enforcement discretion. Something else. Let's see here. We disagree. The registration rule does not merely announce the intent to enforce a pre-existing statutory requirement. The registration rule is a rule that creates a new regulatory regime for model aircraft. And this is one of the other things a lot of people were pointing out when they were writing up their responses to this, sort of like how everybody was typing in their stuff for the FCC, saying, hey, yeah, this is not good. We don't want this kind of stuff. People were putting in that this is a whole new regulation setup for the thing that violates 336. And so they were completely ignoring it and then trying to say, oh, we already have this is all already codified, we're just enacting it. It's like, no, you're changing a lot of stuff in order to enforce this. The new regulatory regime includes a new registration process for online registration model aircraft. The new regulatory regime imposes new requirements to register, to pay fees, to provide information and display identification on people who previously had no obligation to engage with the FAA. And new regulatory regime imposes new penalties, civil and criminal, including prison time on model aircraft owners who do not comply. In short, registration rule is a rule regarding model aircraft. Second, the FAA argues registration rule is consistent with one of the general directives of the FAA Modernization and Reform Act to improve aviation safety. FAA Modernization Reform Act preamble. Aviation safety is obviously an important goal. The registration rule may well help further that goal to some degree, but the registration rule is barred by the text of Section 336 of the Act. See Central Bank of Denver, North America versus First Interstate Bank of Denver. Ooh. Let's see here. Policy considerations cannot override interpretations of the text of structure of the Act. I might have to look at this one a little bit later. So it looks like this is some sort of case law that involves possible regulation issues involving the banking industry from the looks of it. Congress is, of course, always free to repeal or amend its 2012 prohibition on FAA rules regarding model aircraft. Perhaps Congress should also should do so. Perhaps not. In any event, we must follow the statute as written. So basically, it's saying that right now, as the law stands, they cannot do pass any. Well, this new registration system. They do say there is merit in the registration of possibly improving safety issues, but as is, they have to follow by the letter of the law, and they can't impose these new registration rules. The registration situation right there. In short, Section 336 of FAA Modernization and Reform Act prohibits FAA from promulgating any rule or regulation regarding model aircraft. The registration rule is rule regarding model aircraft. Therefore, registration rule is unlawful to the extent that it applies to model aircraft. And we'll go back through once we get done reading all this. We'll take a closer look at the various footnotes. Maybe we'll look up, try to look up the case laws that they throw up in here too. Anyway, moving on. We next consider the challenge to the FAA Advisory Circular 91-57A. And the reason why I'm stating this, the numbers for these, because there is a difference, and we need to distinguish between the two things here. The circular prohibits the operation of model aircraft in certain areas, including Washington, D.C., flight restricted zone. Taylor argues, among other things, that the circular violates Section 336A of FAA Modernization and Reform Act of 2012 because it too is a rule regarding model aircraft. We need to not consider that question because Tyler's challenge is ultimately a person seeking to challenge FAA order must file the challenge within 60 days of the order's issuance. The FAA published a notice of advisory circular 91-57A in Federal Register on September 9th, 2015. Model aircraft operating standards, blah, blah. Taylor filed his petition for review on January 12, 2016, more than 2 months after the 60-day deadline had passed. A court allow a late petition filed if petitioner has reasonable grounds for missing the deadline. 49 U.S.C. Taylor advises 2 grounds for his delay, but neither constitutes reasonable grounds under the statute. First, Taylor argues the FAA did not provide adequate notice that it had issued a new circular. But on September 9, 2015, the FAA published the revisions for the Federal Register, and Congress has determined that the publication in the Federal Register is sufficient to give notice of the contents of the document. Second, Tyler contends the advisory circular itself was so confusing that it did not provide notice about the conduct it prohibited. That is inaccurate. Circular states model aircraft must not operate in prohibited special flight rule areas or the Washington, D.C. capital region flight restriction zone without specific authorization. Ultimately, Tyler admits that he simply did not know about the revised circular until the FAA launched a media blitz to publicize it. Taylor, let's see here. That may be understandable, but under our precedent, Tyler must point to a more to more than simply ignorance of the order. as reasonable grounds for delay. Tyler has not done so. His petition for review of the circular 91-57A is therefore ultimately. His petition for review is ultimately. Let's see. The FAA registration rule violates Section 336 of the FAA Modernization Act. We grant Tyler's petition for review of registration rule. We vacate the registration rule to the extent it applies to model aircraft. Because Tyler's petition for review for Advisory Circular 91-57A is ultimately a petition, is denied. So ordered. So, as it is, the new Advisory Circular 91-57A stands. That hasn't been changed at all. Because he put in a petition to contest it. It was late. There was not a, how should I put it, a viable ground for the argument as it stands. To challenge it for an excuse for missing the deadline for challenging that. But the registration rule has been revoked, which is quite interesting. This is a fun little read here. Let's take a look at this footnote. Note special that Section 333B prohibits, especially preserves the FAA's authority to pursue enforcement action against any person operating a model aircraft to endanger the safety of national airspace. FAA's Modernization Act 36B. That provision, however, is tied to safety. It does not authorize the FAA to enforce any pre-existing registration requirement. So pretty much the safety factor that was already part in play is part of the reason why it stayed. Yo, man. Let's see here. Tyler purports to challenge the FAA's October 2015 announcement that he was reviewing its registration requirements for model aircraft, for clarification for applicability of aircraft registration requirements for unmanned aircraft systems, and requires for information regarding electronic registration. That challenge is assumed by Tyler the challenge registration rule. We therefore do not separately consider it here. I think that was the last footnote that was in here. Yep. So that is a reading of the Taylor v. Huerta decision there. And do you guys have anything to add to this, possibly? Let me bring up the chat here on my big window here so I can see if there's anything. You skip the reading? Nope, nothing really new. And concerned citizens for Constitution. I'm sort of also using my phone and glancing down at the same time to look at all this. Let's take a quick look at the. Let's see if I can look up that one case law that they cited, because the bank one goes down here. Screw it, I'll just type in bank. Here we go. Control F is so handy these days. Central bank. Let's see if we can. Opinions. Oh, cool. We got a Wikipedia. We can just use that to get a summary. Let's blow this up a little bit here. It was a decision by the United States Supreme Court which held that private plaintiffs may not maintain aiding and abetting suits under Security Exchange Act. Where did I cite that? Okay, let me read through this. But the registration rules barred by text section of the Act. See this. Policy considerations cannot override the interpretation of the text structure of the Act. Okay. Majority opinion in the establishment here established that liability did not extend to aiders and abettors that participate in the misstatements or omissions in the connection with the sale of securities. The Supreme Court held that private Civil liability under Rule 10b-5 does not extend to those who do not engage in a manipulative or deceptive practice, but who aid and abet such violation. 10b. This distinguishes between the primary liability of violators of Rule 10b-5 and non-primary defendants who had not directly deceived investors. This is more literal reading than Huerta or whatever of Section 10b of the Securities Exchange Act of 1934 and Securities and Exchange Commission's Rule 10b, which prohibited fraud and deceit in connection with the purchase of sale securities. The Supreme Court ruling reversed a long-standing history of court decisions and does see enforcement actions where aiders and abettors, often banks, accountants, trustees, attorneys, were found liable under Rule 10b-5. This case makes the distinction between primary violators who directly misstate or omit material fact that are relied upon by investors, and aiders and abettors. According to the court, plaintiff must show reliance on the defendant's misstatements or omissions to recover under 10b-5. Basic INC v. Levinson, were we to allow aiding and abetting action procedure in this case, the defendant could be liable without any showing that the plaintiff relied upon the aider or abettor statements or actions. When investors relied on such statements or actions, the court extends Rule 10b-5 liability to these secondary participants. The court stated that any person or entity, including a lawyer, accountable to accountant or bank who employs a manipulative device or makes a material misstatement or omission on which purchase or seller securities lays upon the reliability of the primary violator under 10b-5. So this is, I'm guessing they refer to this because the Supreme Court literally did a change on a lot of court decisions and stuff like that, and also SEC enforcement, because they went and looked specifically at the law, I guess. And so they're saying that we're justified underneath this kind of thing, interpretation. We're citing this case law for that to happen. Let's see here, Mia. So if citizens don't follow FAA, pubs, and when an area concerns them, they are too late to voice concerns because they didn't read the pub's bullshit. I sort of agree with that, but there's also somewhat of a reasoning behind that. Yeah, it's sort of like, okay, I'm going to put out the further public discussion kind of thing. A good example, actually, is when I went and argued, was covering the new drone regulation that the city of Anchorage was trying to impose for flying above people's properties and stuff like that. What they did is they had a general time for where people came in and did their arguments against the case. They set aside that time specifically. And that's pretty much what happened there is they're putting out the policy, you can argue against it, but you can only do it within a certain period of time because they got to move on with business. Now, I do agree that it should be you should be able to push against it when possible, but how should I put it? It's a really tricky thing trying to work that in where it can be reasonably done. But as is where, I mean, we're a nation of rule of laws, and we set up that you have to have a valid reason. I guess I'll have to look at further notes about do further reading into the specific regulations along that line. So that's an interesting court case. So what do you guys think of what we got going on here? Was it quite the interesting reading, understanding. We sort of are all on the same page now of that the registration rule is BS at this point, and unfortunately, the new circulatory is what we're stuck with for now. And I'm really annoyed that I don't have that really showing up. And this has been going on for a good 30 minutes here. Well, almost 40 minutes. Well, I might as well go ahead and end the stream. We've had a pretty good stream going on here. As is, if you want to read the court decision yourself, you can go ahead and check that out in the description. Also, I am still working on trying to get some new shirts designed, throwing the t-shirt market there. Also, check out the other links I have in the bottom for affiliate thing that help out with the channel sponsorship, or I guess you could sort of say. I really do recommend reading the, if you haven't read, getting your hands on and reading, or at least listening to the, what was it? You Have the Right to Remain Innocent book. That is something that I do enjoy reading off and on. Let's see here. Not currently needing any FAA guidelines. I find it helpful to know that what people are going through. Yes, and what was interesting is this guy pretty much filed and fought this all by himself. And that definitely was not a cheap manner, because how expensive it is to push a civil case, especially against the government. It's not a cheap thing. But from what I understand, he's also a lawyer and a UAS hobbyist kind of thing. And I'm pretty sure he was pretty upset when he learned he could no longer fly in the DC area where I guess he lives, so. But as is, I might as well go ahead and end the stream here. And except I'll probably do an outro song here. Oh yeah, and also all music that I do have set up is going through from TechnoAxe. Earlier was Further Investigation. And I think I will throw up the next outro song, Edge of Tomorrow. And also throw up the dancing thing. How does this apply to situation with Tom Zebra? Actually, we'll go ahead and write this down a little bit more. The Tom Zebra case. I might also quickly elaborate on the Tom Zebra case. Roll fast, and we'll throw on the little dancing girl in the rain. The Tom Zebra case, specifically with him, that deals with local ordinances. The Tom Zebra case, what's going on is it looks like he took off within the parking lot of a park area or landed. It's been a long time since I really looked at the original footage. I think he ended up taking that down, or it's hidden or something like that. But that is dealing with a essentially a ordinance for the local municipality. Now, is it in conflict directly with the how should I put it? Is it in direct conflict with FAA governance for flying? Yes. Because the ordinance says you cannot fly over a park, but that is not within their jurisdiction. It can be challenged on that ground, but for the takeoff and landing part, if he was in that parking lot, and I think the parking lot counts as part of the park, then yes, they can get him on that part. The issue with that part, well, the way to get around that issue is to take off and land in the streets for Los Angeles for the most part. So if you're standing on the public sidewalk, that's not part of the park. That is part of the street. That's public right-of-way kind of stuff. Or as Onus did with one of his latest videos, he asked the cops, what about taking off and landing from a house nearby on the other side of the street? That actually is completely legal under current precedent And that is something I actually want to personally challenge myself. But obviously, I'm not in the position to go and deal with my personally. And I would definitely love to do that at some point. There's a lot of stuff that I want to take on. In fact, actually, there's some stuff in copyright that I've been looking at that I want to take on that deals with some, how should I put it, unscrupulous modders. And I will probably put out a different sort of update in the future for me doing something dealing with copyright issues in the future. And it'll be more or less oriented towards gaming and nerd culture, I guess you could sort of say, on the other side. It will also not be politically correct. So just giving you that heads up. I will be saying stuff intentionally to invoke, how should I say, confrontation, because, well, legal confrontation for the Kex. But I might also say, have a good evening, well, afternoon and evening for those in the United States, or for the people of the rest of the world, whatever time period it is for you guys. Update, let's see, does this ruling only apply to DC area or national? Oh, this ruling applies to the, it literally applies to the entire nation, because this affected the FAA. So if the FAA, because the FAA was the National Association, well, the agency itself was penalized, this applies nationwide. It isn't restricted to the Court of Appeals, well, to the Washington, D.C. area, which is standard for case law. Police officers cannot be held liable for use of force consequences even when they provoke violent confrontation. Supreme Court has ruled that already. Los Angeles County v. Mendez. Yeah. I love Tom's thing. Good. F political correctness. Yes, I am staunchly on the freedom of speech side of things. That is for sure. I can understand if your feelings get hurt, but the thing is you have a right to be offended and you have the right to walk away. And that is how freedom of speech is. There are, of course, certain legal stipulations when it comes to that. But those don't always, how should I put it, are considered kind of stuff. And one of the things, my pet peeves that I'm wanting to go and deal with is the Antifa BS that's been ongoing. In fact, actually, I need to redo my recording because I actually have a thing about Antifa violating people's civil rights where they can be sued. Yes, you heard me correct. Antifa people can be sued for violating people's civil rights. And I just realized I forgot I did a timing on the delay. It's roughly 60 to 90 seconds delay between when you guys hear me when I say something and it going out. Videos on your channel. Let's see. Video for ads, you must be licensed. Actually, that one is still up in the air. With Concerned Citizen. Thank you. What about making your own ads for your own vids on your own channel? Not to rely on YouTube ads. I understand any drone video for ads must be licensed. Here's the deal. The distinction between hobbyists and those doing it for commercial, as a commercial thing. There is a clear distinction. When it comes down to it, a hobbyist is legally allowed to make money underneath the IRS coded IRS tax standings. The trick is hobbyists cannot claim their expenditures for a tax deduction for a business. Now, this is something I went through. I haven't really gone through and looked up the full latest stuff. Supposedly, from what I've been hearing, what some people have been saying, that if you make any cent on your stuff, you're supposed to go register for 107. I don't really see that. I still have to go back through and reread. I mean, really fine tooth comb those changes, but I don't see grounds for having to register. Well, having to get a 107 for running ads on your YouTube videos when you're just a drone hobbyist flying around, kind of shit, goofing off. And quite often, I mean, I goof off when I can with my drone. Unfortunately, my battery is on the kaput side. I need to get a replacement, but I haven't been able to afford a replacement because I've been having to replace camera equipment and computer parts. In fact, I just replaced the hard drive, a hard drive in my computer that was over 11 years old. And I'm actually surprised it lasted that long. I still got to go through and kill off the erase the data off that hard drive. I don't know if I'll continue using it for something else, but it's pretty large. I'm all for talking shit, for not getting in my way and forcing me to go around you because you want. Don't do it to others, and I expect the same back. Yeah, it comes into, well, when it comes down to talking shit, that's more or less a moral issue kind of thing, and morals can't really be technically regulated to some extent. I mean, like, the obvious, like, murder and theft, yes, can be. But that's a whole freedom of speech. Wow, that is a long time. Holy hell. I'm not sure. Yeah, I'm not sure if you're referring to the delay or whatnot on the me chatting out to you guys. I'm not sure how fast the chat gets back when you type in. So, but anyway, it's been about an hour. I might as well hop off on this part. It will take a little bit for the YouTube to process it, but it should be up shortly after all that. And I will probably do an Antifa thing, and I think I'll actually go and look at the Tom Zebra thing a little bit later on. Also, I'm probably going to end up starting to do more live streams because apparently people are saying the super chat system is what's sort of drawing in the money. Of course, I am small time. I'm not expecting much on the super chat, and I can more easily get away with doing this podcast setup right now, kind of thing, for the time being. But I'm not sure how much longer that'll last. But anyway, good evening, good afternoon, and good morning.